morning. This is the time and place for the continued investigatory workshop in docket number 17-10001, which is the Public Utilities Commission investigation into the Energy Choice Initiative. My name is Joe Reynolds, and I'm the chairman of the commission and the presiding officer over this matter. This morning is day 5 of our workshops, and the intent of today is to revisit any issues that were left open-ended from last week's discussion. And the issue topic for today is amendments or repeals to any current Nevada laws, policies, or existing energy programs that may be necessary to establish an open and competitive electricity market in Nevada. Some things and some ground that we covered last week that does make the ballot initiative unique to Nevada, and that we're doing something new throughout the country is the constitutional amendment aspect of this initiative. And I think it's important, again, to read the language that's proposed to be put in our Constitution if this initiative passes, because that is the cornerstone of everything that will be built from that. And though I read this into the record previously, it's helpful for me, and I think it's important to put this out there again. And so the Energy Choice Initiative is a proposed amendment to Article 1 of the Nevada Constitution. It's broken up into 4 main sections, and I look at it. The first one is a declaration of policy, which I think is the intent of the initiative. And it states, the people of the state of Nevada declare that it is the policy of the state that electricity markets be open and competitive so that all electricity customers are afforded meaningful choices among different providers, and that economic and regulatory burdens be minimized in order to promote competition and choices in the electric energy market. This act shall be liberally construed to achieve this purpose. The second section in the amendment is the rights of electric energy users. And this provides, effective upon the date set forth in subsection 3, every person, business, association of persons or businesses, state agency, political subdivision of the state of Nevada, or any other entity in Nevada has the right to choose the provider of its electric utility service, including but not limited to selecting providers from a competitive retail electric market or by producing electricity for themselves or in association with others, and shall not be forced to purchase energy from one provider. Nothing herein shall be construed as limiting such persons or entities' rights to sell, trade, or otherwise dispose of electricity. The third section of the amendment is broken into 3 subparts, A, B, and C, and sets forth, I think, the timeline that the state will be looking under. The 3A provides, not later than July 1st of 2023, the legislature shall provide by law for provisions consistent with this act to establish an open, competitive retail electric energy market, to ensure that protections are established that entitle customers to safe, reliable, and competitively priced electricity, including but not limited to provisions that reduce cost to customers, protect against service disconnection and unfair practices, and prohibit the grant of monopolies in exclusive franchises for the generation of electricity. The legislature need not provide for the deregulation of or distribution of electricity in order to establish a competitive market consistent with this act. Section 3B provides, upon enactment of any law by the legislature pursuant to this act before July 1st, 2023, and not later than that date, any laws, regulations, regulatory orders, or other provisions which conflict with this act will be void. However, the legislature may enact legislation consistent with this act that provides for an open electric energy market in part or in whole before July 1st, 2023. Subsection 3C provides, nothing herein shall be construed to invalidate Nevada's public policies on renewable energy, energy efficiency, and environmental protection, or to limit the legislature's ability to impose such policies on participants in a competitive electricity market. And the fourth section of the proposed constitutional amendment discusses severability. Should any part of this act be declared invalid, or the application thereof to any person, thing, or is held invalid, such invalidity shall not affect the remaining provisions or application of this act, which can be given effect without the invalid provision or application. And to this end, the provisions of this act are declared to be severable. This subsection shall be construed broadly to preserve and effectuate the declared purpose of this act. As we discussed during last week's meeting, again, because it's a constitutional amendment, I think at some point every word and conjunction and comma, period, may be looked at different times, as happens with other constitutional amendments and constitutional provisions. And so I have some just follow-up ideas or some summation of some points that I've taken away from our last week's discussion that I've initially wanted to go over and put out there again. If there's anyone participating either here in Carson City or in Las Vegas who can attempt to answer these or wants to come on the record and discuss them, it's very much appreciated. And then we'll also turn over the microphones to anyone who would like to give more comments or propose questions that I haven't hit upon. Something during last week's first workshop is we heard from some participants about which laws will need to change. The regulatory operations staff stated there would need to be a full rewrite of several Nevada Revised Statutes chapters. In many chapters in our Nevada Administrative Code will also likely have to be rewritten. And in looking at what those may be, when we discussed last week of the overall purposes and intent of this provision, or constitutional amendment, I think a vision in my mind started to crystallize more of some points that this intends to achieve. It may be looked at in that, and one of my takeaways so far is that Indy Energy will still be in charge and running distribution unless the legislature says otherwise, but that the constitutional amendment doesn't necessarily impact or invalidate the distribution components, often referred to the wires components, that they'll still have control of the roads, so to speak, that the energy travels upon. So Indy Energy is still very much a participant in the discussion and in the energy conversations, even if this does pass. The transmission components of rates are largely set by FERC, the Federal Energy Regulatory Commission, though those are incorporated into our bundled rate component that comes before the Commission when we adjudicate our triennial rate cases. That piece will still largely be under FERC control. And so what we're looking at opening up through this amendment is essentially the generation component of a rate structure, and also the customer costs that are charged by an actual retail provider. And with respect to that, so I would imagine laws in NRS Chapter 704-110 that currently require the Commission to do a general rate case to set those generation rates for NV Energy and Sierra Pacific Power Territory as well as Nevada Power Territory would need to be amended so that the Commission doesn't have that general rate case with respect to the generation component. My understanding that there still could, under this constitutional amendment be a rate function setting for the distribution components. It's certainly not as lengthy or onerous as with the generation, but there's still some of that oversight that could be maintained. Also, we would need to look at licensing and new legal licensing provisions for the legislature for new prospective businesses that want to enter the retail market here in Nevada. And along with some of that vetting, we'd need to look at the creditworthiness of new businesses that want to participate in Nevada. We would want to look at their capacity, their financial solvency, and also what type of resources they would be able to bring to the state. And so there would be a new vetting function. And so what we would want to look at is creating some new NRS provisions, I would imagine, to allow for that vetting function to occur. I don't know if it's fully analogous, but the Gaming Control Board does some of those functions in the Gaming Commission in terms of new prospective gaming businesses in the state. They investigate those businesses, creditworthiness, and so forth to make sure that they meet the criteria established by our policymakers in order to do business in the state. I would imagine new legislation would need to be enacted or looked at along this lines regarding consumer protections, deceptive trade practices, any type of fraud, to ensure that any of the businesses that would come into a new marketplace are doing what they're supposed to be doing, and an enforcement component of that. That we need to look at also changing our what we call our integrated resource planning process, our IRP process. In what I gathered from our conversations last week, that might just need to morph a little bit. Right now, we have the IRP planning process that we work with NV Energy, look at short-term and long-term energy needs or resource needs in that. And from what I gather, that needs just to be rethought, in that we might look at that statewide in terms of making sure any resource planning goals that are set by our state legislature are being met comprehensively by the different market participants. There would still be, and so what I gather also from the legal discussions last week, this isn't necessarily full deregulation. I would look at it as re-regulation. There's still regulatory components, legal oversight, and checks that would be in place if this constitutional amendment passes. And so that's at least the intent from some of the sponsors and supporters that I heard from. And those are areas where I think some of our laws would need to change. Other discussions that we discussed were what are often referred to as public policy components in our bundled rates. And I heard that it's the intent, at least of the drafters, to allow the ability of the legislature to keep intact some of those components of the rates, and require businesses who come in to the state to work into what they charge customers, universal electric charge or the energy efficiency charges could still be there. At least there's not an intent to strip the legislature's ability to have those laws in those public policy charges in the rate process. At least that's what I recall hearing. If my understanding is incorrect in any way, I would ask anyone to come up and correct me on the record or clarify that. But that's so far kind of a broad view of where, at least what I gathered from last week's conversations. And so in my mind, a vision is starting to emerge of what this might look like. And in some ways, it's a drastic departure, and in other ways, at least, it isn't, in the sense of it's not completely throwing our entire regulatory framework away. It's changing it. But there's still some key pieces that would remain in place. And so I'd ask, at least at this point, is if my understanding so far is accurate, or folks think that it's inaccurate in anything I've said, I'd invite anyone to come up and clarify or correct me if anyone would like to. Good morning, Mr. Wellinghoff, and thank you for coming up. I appreciate it.
Good morning, Chairman Reynolds. John Wellinghoff on behalf of ACI. I don't have any corrections, and I think, as I understand last week's discussion, and I wasn't here, I apologize for not making it to that session. Actually, I had to go to Canada instead. I would rather have been here, believe me. But I just wanted to add one dimension here that at least ought to be considered, that I would agree is not specifically in the constitutional amendment, but may be an adjunct that could provide some additional benefits to consumers, and that is that you talked about NV Energy still running the distribution system. I think we need to be open to the possibility that we could have an independent system operator for the distribution system, an IDSO. They're considering this in Hawaii, they've done it in Denmark. And ultimately, it could provide for more competitive services down at the distribution level. If you have somebody who independently runs the system and plans on the system, which would be analogous to an ISO that does it at the wholesale level, you do it at the distribution level as well. Provide for distribution markets for voltage VAR support. It could provide for competitive services such as voltage control and other things that could be done by consumers on their side of the meter. And if you have an independent entity who's making those decisions, it might be easier to do rather than if you have someone who has a vested interest in whether they do it on their side of the meter at the distribution level. So it's just an option I think we ought to at least keep open on the table. What can you explain even some more what that would look like? I'm asking just to learn for myself. Sure. The best analogy is it would look exactly like CAISO, like the California ISO, except it would be down at the distribution level. So the PUC would be over a independent nonprofit board that would have a staff that would be run as a nonprofit that would operate the distribution system, and it would plan on the distribution system and provide you with that planning construct. You would still be in charge of the distribution system as the PUC, but you would have an independent entity who would run any market services at the distribution level, because you shouldn't have somebody running market services who also is benefiting from those market services. That's why FERC created independent entities at the ISO level. And also, FERC felt you shouldn't have the owner of that transmission planning on it either. That's why CAISO does the planning instead of PG&E or Southern California Edison, for example. So you'd have an independent entity who would be doing that operation and planning to provide for more opportunities for open, transparent, and competitive system at the distribution level. It would be completely analogous to what you do at the ISO.
Thank you. And in my reading, especially with Section 3A, it provides that there's authority for the legislature that's not restricted by the constitutional amendment to, look more closely and do something different with the distribution aspect of this, or not, or leave the current framework?
I think they have complete authority. I think they have the authority without the constitutional amendment. I think they could do this anyway, but I want to suggest that it may provide for more competitive options and make a more robust competitive structure if we look at an independent operator at the distribution level.
Do you think, which is why I have you up here on the microphone and I can pick your brain just a little bit, Mr. Wellenhoff, is there any logic that if the legislature had the appetite to look more closely at the distribution framework that we have in place, to kind of doing it all at once, or do we look at, as a state, implementing some of the immediate required changes that would come through this constitutional amendment, and then look at, a few years down the road, look at the distribution possibilities? Or do you think there's wisdom in just, if we're gonna go in there and do some changes, just to do it all at once?
I think you could do it either way. There may be some arguments to be made that if you do the constitutional amendment changes first and see if there are then any restrictions because of the distribution system structure that you may want to change it later. So there may be some reason to wait, like you're suggesting, and do it in stages rather than to do it all at once. But I can see arguments for the other side of it as well.
Thank you for that. Good morning, Mr. Weber. Thank you for being here.
Thank you, Mr. Chairman. Josh Weber for the record. I just wanted to make a brief comment that I thought that your summary that you put together for us this morning is quite good. I didn't try to make a note to see, well, do I agree with every word or not, but I think it's generally a very good picture of the landscape that those who drafted the initiative envisioned, at least at a very basic level. There's obviously a lot of details to be filled in that skeletal structure that you put forward. So I appreciate that, and would say that generally I think that we agree with your description. One other item though, last week you specifically asked me whether or not, from a drafting perspective, this is a scratch everything and start over, or is it go back in and change this provision, change that provision, and redline half of the statute. And I asked you to give me a week to think about that one. I would like to comment, I believe that staff said that they were leaning toward the idea that it's probably better to start with whole cloth. And upon reflection, I think that is probably will end up being a better approach. But I wanted to comment on it at this point because as you were describing the things that may remain or that need less tweaking, I think that while we may need to sit down and think about this from a new framework and say, what do we do with 703 and 704? Do we start from scratch and how we're going to put those together? I think that's probably right, but it doesn't necessarily mean that we have to rewrite all the provisions. And I think an excellent example, and the reason I jumped up to talk about it now, was the distribution rate case rules. It may be that a significant, assuming that we stay with the structure, and I think it's a fascinating thought process that Mr. Wellenhoff suggested that really ought to be looked at, but assuming that we stay with a structure that is relatively similar to what we have at this point for the distribution system, it may be that a very large piece of the statute may need to be moved to a new place, and it probably will have a number of tweaks that have to be done to it, but we don't necessarily have to rewrite everything. There are big chunks that can probably be moved directly over to whatever that whole cloth looks like. There are always stakeholders who wish things were a little different in statute, and so it may be that this is an opportunity for NV, for those who regularly intervene, for staff, BCP, to say, we like most of what's in this distribution rate case rule, but let's also do these things to it to make it work better, not just to make sure it fits in the ECI framework, but to improve it. We have a lot of experience using it.
No, thank you for those comments, and I hear what you're saying, and that it's possible. And again, this is ultimately up to the legislature, and I imagine they'll hear from a lot of voices, different lobbyists, different interests, on this. But I guess what I was trying to frame, and thank you for your comments, is this provision is trying to change certain things, the status quo about the way we regulate energy in the state. There's other things it's not necessarily intending to change. And while we're going to go, the legislature is going to go in and look at how to effectuate these changes in NRS provisions, there's other pieces, policies, procedures. The statute numbers may change, the subsection numbers may change, but the actual bulk of some of that language may get moved around, but it not necessarily is going to be burned and to the side. And so on one hand, we're reshaping the wheel, but not necessarily reinventing it, perhaps. And I think some of those practical concerns, are important. Again, where we have our legislature that works under a time frame itself, and the more we can go and kind of do a narrowly tailored surgery, is one thing to look at. And so I appreciate your comments. And ultimately, it's not my decision, and it's decision of, again, the policymakers and the other branch of government, but want to try to help crystallize some of those conversations, or the purpose of this investigation is, again, to try to address some of those decision points in kind of a roadmap going forward on where some of the discussions may need to go next. So, thank you. Good morning, Ms. Carolyn Barbash from NP Energy.
Good morning, Chairman Reynolds. I just have a couple of comments on the opening statements. One was around the IRP process and needing to morph that in the statutes. I think it may not be that simple. I think the integrated resource planning process that we do today is a true integrated resource planning process when the Commission reviews the load forecasts and the resource additions and retirements, as well as how that integrates with the transmission system, etc., as you well know. If the constitutional amendment passes, Nevada will probably need a new resource adequacy program rather than morphing its existing IRP process in order to ensure that Nevada's electric providers have sufficient resources to serve Nevada. And although Nevada will still have the ability to establish the parameters around that resource adequacy program, they will most likely be implemented through a FERC-approved wholesale market tariff. And so it's really more of a matter of more federal jurisdiction involvement in the resource adequacy program and how that may affect Nevada's ability on certain resource mix requirements, etc. So just wanted to comment on that. And then I agree also with you on, it sounded like the drafters of the initiative wanted to keep the public policy programs intact. I think I heard that as well, and continue to have those in the electric rates. But then I also heard that Nevada would still regulate everything except for the electricity prices. So I didn't know how those two things would work together if Nevada wasn't regulating electric prices, how those public policies work in that environment.
No, I think those are. I'm trying to think of the say this. There's ways to take, there's a lot of words in this constitutional amendment, and there's moving parts. I don't think it's saying anything that anyone else hasn't already recognized. There may be litigation, there may be lawsuits that come from interpretations, application of this. There may be a lot of them. I don't know. To challenge, again, when you're having the tension sometimes that exists between the constitutional provision and statutes, as well as then application of those and the creation of regulations. There's a lot of issues to work out with. There's a lot of lawyers involved, and I don't think it's, again, a stretch to envision litigation that comes out of this. And I'm just looking at the scope of this investigatory workshop is, I'm looking at the how-to. How do we and if others are going to challenge, that, the courts will decide those in things of that sort. And so I'm trying to understand the vision of the petition and try to see how we can make it happen. Yeah, Mr. Weber.
Thank you, Josh Weber, for the record. I think Ms. Barbash made an excellent point that perhaps we may have spoken a little too imprecisely at some points, so it's a good opportunity perhaps to clear it up. The question of whether or not the commission regulates the price of the energy commodity, I think should be stated. The commission does not set the price of the energy commodity, because it's a fantastic point. If we're talking about a new regulatory construct and the commission says, well, we're going to add a mill tax of XYZ, and you add that to the market price, well, you just regulated the price of the commodity, even though, or the price that's paid, even though the market set the price. So I think it is a very good distinction, and I want to be clear that that's what we're talking about. We're not talking about stripping away the ability of the state and the commission specifically to regulate a number of factors that are going to affect that final bill, and that's one of the reasons why there's so many unknowns at this point, because we don't know what those pieces are going to be that affect the final bill. But absolutely, I think set, not regulate, is a better way to put that from our perspective.
And so that would make public policy programs market-based pricing instead of regulatory set pricing. I just want to make sure I understand the market setting versus market setting the prices versus a regulated price.
Josh Weber, again, the idea would be that there's public policy programs have costs associated with them, and they would be regulatorily set. But the price of the energy that folks are buying is set by market forces.
And that's kind of, we put kind of just a general chart up here in Carson City in the hearing room, and broke down, some of the different components currently in our bundled pricing. And we have the energy generation components, and the generation itself is roughly about a third of the overall kilowatt per hour pricing. We have the public policy piece, the transmission piece, the distribution piece, and then a customer facility piece that's also in there, as well as the energy, just the basic charge of the fuel costs. And at least my understanding is it's the intent. And again, somebody could file a legal challenge and say that's unconstitutional because there's provisions that say meaningful choice, open competitive market. but the intent is to still, when we look at these different components of the rate, allow the legislature the ability to say, as a matter of law in Nevada, we want, X number, a certain percentage of all bills to, again, you can call it a tax, a fee, a charge. People put different spins on what it is, but essentially it's a public policy, legislatively imposed monetary payment on people's bills to serve greater public policy objectives. And then the transmission component, again, would largely be the federal government. The distribution component of that would still be under Public Utilities Commission regulation to be set in, but the customer facility charge, basic service charge, will be up to more free market forces. Right now, the commission sets that, and also the commission sets, the generation pieces and energy pieces. Those would be opened up. And in opening them up, they could go up, they could go down, and that exposes consumers in Nevada to more of that competitive market aspect. And as everyone sees, when we open any area up to not having regulation on those pieces, they can again go up and they can go down. Whether it's gasoline, whether it's airline prices, whatever it is. In that there's a risk in doing that. There's potential benefit in doing that, and I think that's what we're looking at.
Josh Weber for the record. Mr. Chairman, if I could just clarify, I wasn't sure if I heard properly, but the basic customer service charge you mentioned, to the extent that that basic customer service charge is paying for the poles and wires, it would be my understanding that there is no need for that to be, under the initiative, there is no need for that to be competitive. Of course, the legislature can do whatever the legislature wants to do, and as Mr. Wellinghoff pointed out, there are lots of services, including things to do with poles and wires, that can be competitive, but I just wanted to make that distinction because I wasn't sure if I understood your
No, and thank you for that. And I guess part of me, is thinking in terms of, there's raw generation costs that retail providers, can purchase. But then there's costs of paying the employees, paying the folks who answer the phone, paying for sending out the billing statements, for the service trucks, and that has to be borne in at some level. In order for companies to make money, and that's a competitive price point where I think companies will come in and do it cheaper or offer to do it cheaper than others using different technology or different marketing, or that I think that's the advantages of opening up to that competition as you get then different entities thinking of new ways to provide services to their customers at a lower cost.
Thank you, Josh Weber, for the record. I understand clearly now. Thanks.
Mr. Wellinghoff.
Thank you, Mr. Chairman. John Wellinghoff for ECI for the record. I just wanted to make sure that there's no misunderstanding on the record with respect to IRP. I would agree that when we go to a resource adequacy type structure, there may need to be revisions and perhaps substantial revisions to the existing Integrated Resource Planning Act, which I will mention I actually drafted that act in 1983. But I would say that those resource adequacy provisions with respect to the REPs, the retail energy providers, will not be under FERC's jurisdiction. Yes, if Nevada joins the CAISO will have resource adequacy requirements for its participants, which would include load-serving entities, and they will have to provide for making sure that there's deliverability, and the Lutheran entities must provide for that. But even the CAISO admits on their website that its efforts in resource adequacy simply complement the state's efforts to implement resource adequacy programs. So the state, in this case Nevada, would have full authority and jurisdiction over those retail entities to require them to have resource adequacy requirements to ensure they would meet the reliability needs as saw fit by this commission.
No, thank you for that clarification, Mr. Wellinghoff. Another aspect, again, of what laws may need to be changed or amended, that we discussed last week, is the aspect that this constitutional amendment is creating a new right in our Constitution. It's a constitutional right, and I don't want to go too much on the side, but I always think of our Constitution as there's the natural law and inalienable rights, that are endowed by God to man, in our Constitution. Recognizes those, doesn't always create those, and I was thinking in my mind about the quest for fire that existed way back to primitive times, and a right to energy that dates maybe back then. But in more seriousness, in creating and recognizing a new constitutional right, is there thought that's been given to litigation that might arise out of that? Again, 1983 actions, deprivation of constitutional rights, impacts to existing local ordinances or laws, or other areas of the law that look at zoning restrictions, land use restrictions, tax implications. Does there need to be more inquiry into that, into some of those other areas of law that might not immediately seem to touch energy, and but might have implications to these provisions? And maybe that's too expansive of a question or beyond the scope, but that was just one in my mind that came from our conversations last week. Mr. Weber, thank you for coming up.
Sure, Josh Weber for the record. The intent of the drafters was that this would only create one limited right, and that is, as stated in the second subsection there, the right to choose the provider of its electric service. Now, folks have looked at this, and we've certainly heard last week and in other areas, folks have looked at this list, including but not limited to, and said, well, okay, now we have a right to the market, we have a right to throw up a miniature nuclear plant in my backyard because I have a right to generate here. But the text very intentionally does not say that you have a right to generate. It says you have a right to choose. So that's an important distinction that I think those all who worked on drafting this wanted to make very clear. Now, the reason for that is that in order to choose, to have meaningful choice, you have to have some choices. But the right to make a choice really is a right not to be captive to a monopoly. It doesn't necessarily follow that you have an unfettered right to do anything related to that choice. Whether there will be litigation or not, I certainly, as you've clearly stated, there's lots of lawyers and they like to sue. I couldn't comment on that one.
I appreciate that, and I that's why I wouldn't go there either, because who knows? And I think that clarification, at least for me, is important. You know, 3 or 4 weeks ago, before we even had some of these workshops, you know, I heard some of those same concerns as well, and I think it's important to again crystallize the intent and some of the scope of what this is trying to achieve. Because I think then it takes some of the more absurd or ridiculous hypotheticals off the table, and I think it make it just a good thing, and that's something that I wanted to get from this conversation from the workshops is some of the over the top what ifs. And at least in my experience in interpreting statutory and constitutional provisions, and as just a lawyer in working with those, what's not said is as important sometimes as what is said. And so intentional omission of language can be as meaningful as the inclusion of specific language. So I appreciate you clarifying that as well on the record. Also, when we discussed last week is with respect to the implementation provisions in Section 3, should this provision pass, that there's language in there that would allow the legislature, if it chose to do so, to start enacting legislation as soon as next spring. And while there's a drop dead end date of July 1st, 2023, I read also in there that there's language that they can get to work much sooner than that, and can start having some of these changes, at least in a phased approach. And along those lines, we also discussed the idea of, and I think that there needs to be discussion, and I don't know how much, at least at this point, we'd be able to get into it, some transitional laws, or some sections contemplated not necessarily to be permanent NRS, but to account for a transition period, whether there is caps, some type of caps in place, different studies that might need legislation with respect to the commissioning or authorizing studies. That's something that CAISO had discussed and I think was advocating for in looking at some of the wholesale market options, and whether there is any BDR that could direct whether it's the PUC or somewhere else to look at those studies, appropriate some funding for those, who'd even do those types of studies, in again with a body of possible transitioning legislation as well. What we've heard from other states is to mitigate against any kind of rate shock, and not saying that there will be, but part of this is we want to make sure that we mitigate any, to make any transition that occurs as smooth as possible, as seamless as possible, that the ratepayers and businesses don't experience anything drastic or negative. What types of laws can be put in place consistent with these constitutional provisions, but also allow for that safety net. Any further thoughts on that, Mr. Weber?
Josh Weber for the record. I suppose the only further thought would be that we agree. What you say is well stated. It's clearly, if there are transition issues that have to be addressed, once a transition is over, those are no longer meaningful, whether they stay or expire. I think that's up to the legislature and legislative council to decide how to structure them. But certainly the intent here was to create enough space for the legislature and by extension, by delegation, very likely this commission, to phase in a new regulatory construct in the most clean, efficient, but also safe manner. And so that is very much part of the reason why this was drafted as a constitutional amendment, because it was able to, the drafters were able to say, okay, so here's policy, and here's a couple of bounds. No monopoly on electric generation and meaningful choice, let's say. And then in between those, there's a lot of space, and intentionally a lot of space for the legislature, as many iterations as necessary, as many as it takes, and also the commission or other state agencies to make sure that happens cleanly and with customer protections in place.
Oh, and I guess when I say even transition, laws that maybe have sunset provisions, and whether it's for certain positions, again, whether it's even in the Public Utilities Commission to help with some of the retail and market structure issues, so that not necessarily intent to create a new position or something that's there forever, but also to help, I think, with some of the more detailed, intricate work, in the coming years that will be necessary. And also, while the commission, is still doing its current duties, where we got a lot of exciting laws that we're implementing and investigations going on, and still the rate making process that the commission is doing as well. And so I guess that's what, at least a carve out, as I'm looking at trying to quantify these different issues of the possibilities of transitional laws that are enacted. And I think, as we've discussed, other states have done this, and to look at what worked and didn't work, especially with the ability of some type of rate cap. Again, just as a backstop, some may challenge the constitutional ability of doing that under this. I don't know, but I still think it's important to have that discussion.
And Josh Weber, for the record, I would say, we're not at a point in this process where we would be able to, specifically on this issue of a rate cap, advocate for or against a rate cap. We understand the arguments on both sides. The one thing that we've seen from experience is that you have to think that through, so you don't have your retail rates doing one thing with a cap and your wholesale rates uncapped going the other direction. So it has to be done properly and carefully. We have good examples of it if that becomes necessary. But the only real contribution I probably could make to that statement at this time is that there is room, I think, and I think that this amendment very clearly gives the legislature the power to do that, because it says shall impose such laws as are necessary to carry this out. And subsection 4, which went dark on me, also notes that the legislature that it is not just existing public policies that are not intended to be abrogated by this initiative, but it also does not prevent the legislature from having the ability to put new public policies in place, which of course will be codified in law.
And thank you for that comment. And I want to be clear: I'm not advocating for that at all. I think one thing that I've heard so far is if done imprudently or a rate cap or something could be very destructive. And part of the point of this is to let the market in market forces operate, And sometimes the best thing that the government can do is stand back and let that work. And so, not advocating for it, but just also recognizing that it's something we've heard about, and something I think to at least look at and discuss. Good morning, Ms. Twilliger, on behalf of Regulatory Operations staff.
Thank you, Chairman. Debra Twilliger on behalf of staff. I come up here for your original question. Some of the legal implications from this initiative that were unforeseen or could happen, and so I just wanted, in some of our thinking about this issue since last week, I just wanted to note a few things. I guess I still have some confusion. Mr. Weber says there's no right to generate, and he's right, the words aren't there that say right to generate, but it does say right to choose the provider of its electric utility service, and then there's several words in between and commas. But then it says by producing electricity for themselves or in association with others. So yes, it doesn't say right to generate, and I haven't boned up on my case law of late where offsetting commas and this other language, how that affects the language that's in the initiative, how we might from an interpretation standpoint read this. But certainly I think the way I would read this is that you have the right to choose, and one of the ways you can choose is by producing your own electricity for yourself or in association with others, which would be the right to generate electricity for yourself or in association with others. So I guess one of the issues we foresee is, for example, there are local ordinances, county and state, that do not allow you to be off-grid. You have to connect to electricity if you're going to get a certificate of occupancy. Does that mean that those laws or those provisions need to change? Perhaps. Certainly one thing I could foresee as well, or we could foresee as well, is that this isn't a right, this doesn't create a right, it does create a right for you to sell perhaps, but not for someone to have to buy your electricity. So this gets into, if we have net metering and AB 405 survives, certainly that there are customers who will be net metered, and that therefore their generation in excess of what they use will be netted to what they do use from the grid. But what happens when you get into aggregators or large aggregators who then have to become QFs, qualifying facilities, and PURPA kicks in. There's been a lot of legislation, or a lot of litigation lately of PURPA in Montana. There's been a lot, I'm sure Mr. Wellinghoff has some familiarity with all that litigation that's going on with QFs and PURPA right now. So I think, those are issues we could foresee being an issue. And I did want to, just on the ongoing conversation you had with Mr. Weber. Well, first, I wanted to address something Mr. Wellinghoff said about Nevada maintaining its resource adequacy, that even if the IRP statute has to change, which it will, we would maintain authority for resource adequacy. I don't disagree with that statement, but I do think that doesn't foreclose challenges for federal preemption, dormant commerce clause. So there are backstops or limits to how much authority we have once we're in a wholesale market that we'll have to pay attention to and make sure we don't create a program like Maryland did in the Hughes v. Town case, where we're faced with a federal preemption argument for some program we have. And the last thing, it was your last conversation with Mr. Weber about that, that this creates enough space for the legislature to do various things. And I think you're struggling with the same thing. I'm struggling with that this is a constitutional amendment, and it doesn't say we have to have provisions that reduce costs to customers only during the transition. It doesn't say that this provision sunsets. So I guess a question that I'm still left with, if the legislature is required to provide by law to ensure protections are established to entitle customers to safe, reliable, and competitively priced electricity, including but not limited to what does that mean? Does that mean that if we had a rate cap and then we get rid of our rate cap because we think the market's working, but then prices spike because of all natural gas prices go up? And I'm not sure that will happen anytime soon, but something else happens. We have weather or something, prices go up, we have volatility, and we no longer have provisions that reduce there's not this mechanism to reduce costs to customers or to control costs to customers. What do we have a constitutional violation then? Because it doesn't say it sunsets during the sort of nascent version of this market. So I guess I still struggle with it. This is a constitutional amendment, and these rights move on even after this market assuming it gets up, it's operating well, and these things go away, and I struggle with how we read those for what we're supposed to do into the future. So that's all.
No, and I appreciate those, and all of three of you at the microphone and myself, we're all lawyers. And I said this last week, some of these questions, the only opinions that matter are the 7 justices of our Nevada Supreme Court. And they're the final arbiters of our state constitution, unless there's a federal, implication with the United States Constitution, which would ultimately go up to the U.S. Supreme Court. Those our 7 justices, our esteemed 7 justices, their opinion matters. At the end of the day, anybody else's in terms of what the final word and the interpretations are. And I'm not. The purpose of my workshop is to better understand the intent of the legislation, and again, for the purpose of what laws need to be changed or not changed, based upon what we know and what the proponents are trying to achieve here. Whether intent ultimately matches the plain language, again, it's something for the Nevada Supreme Court to decide if somebody wants to ever challenge that. My opinion, I don't think means much in that respect, and I want to try to understand the intent of it and make good recommendations that could be useful to the governor, to the Governor's Committee on Energy Choice, to the legislature's Energy Committee, and the general public. So, Mr. Wellinghoff or Mr. Weber, do you have any response to Mr. Twilliger's comments?
I have 2 points. John Wellinghoff for ECI. One is first on this issue of the right to self-generate. I don't know how many people in the room here realize, but AB 405, which was passed by the last session of the legislature, specifically has in it the right to self-generate. So we now have it in statute. I put it in there, by the way. We have in statute the right to self-generate. It already exists. Admittedly, if it was a constitutional amendment, it may have some higher level of preemption or authority, but it's still, all the issues you're talking about, whether or not it preempts local laws, etc., is all has to be considered because it's in state law right now. So I don't think that's really something you can put on the constitutional amendment. It's something that's already there and has to be considered and dealt with. Second point I'd make, I'll give you my legal opinion. Nevada is already in a wholesale market right now. They're in the bilateral wholesale market under FERC's authority. And FERC gains no more authority over this state by Nevada Power voluntarily joining the California ISO, and that's what would happen. There would be a voluntary joining of an association of transmission owners, which the California ISO is, than if they don't. That authority stays the same. FERC can't gain any additional authority simply by a transmission owner who is under FERC's jurisdiction voluntarily deciding to join an independent market that will operate the market, operate the transmission system, and do the planning on the transmission system. That's what that independent entity does. But that doesn't give FERC any more authority or less authority over the state of Nevada. I want to make that really clear.
Thank you. Anything further, Mr. Weber?
Yeah, a couple of points, Josh Weber for the record. I appreciated Mr. Wilger's comments because it helped to focus. I know we've talked about there being some issues that folks are having with clarity. That was very helpful to focus what the issues really are. I wanted to point out, and Mr. Wellinghoff already noted that there's a right to self-generate in state law currently. But when the paragraph gives every Nevadan a right to choose, and that's the right, it does, as Mr. Wilder pointed out, include selecting somebody from a retail market or producing electricity by themselves or joining in an association with others to acquire their electric commodity. So it is clear that those three, not limited to those three, but those three paths to acquiring electricity are certainly part of that right. It's sort of a minimum that's set there. But I think the point that I was trying to make when I said, look, the right is to make a choice, not an unfettered right to do these three things that are listed as examples below. For instance, choose the provider of its electric service by selecting providers from a competitive retail market. But that doesn't mean we can go and select a plan in Texas for our home in Nevada. It doesn't mean that we can participate in any retail market that we want. It does, however, mean that a Nevadan has a right to make a choice, and one of the options that they have to be able to reach for is somebody in a competitive market. Likewise, there's an opportunity to make a choice. One of the options needs to be the option of self-generating. So that means that this does require that there is the ability to make a choice to exercise that pre-existing right to self-generate. So I certainly take Mr. Williger's comments. I think that she's absolutely right that these three ways of acquiring electricity are part of that right, but I hope that helps in terms of my earlier statement. It's a right to choose versus, well, you've got three things listed here. Well, yes, but you don't have an unfettered right to choose. The intent here was not to strip home rule laws and the authority of counties or cities or the state to do appropriate regulation. We don't have a position on what level of regulation is appropriate. There's lots of positions on that, and we're not going to take one at this time. But it is rather the opportunity to make a choice rather than be held in a monopoly. And on a related point, if I can...
Yeah, go ahead, please.
I thought it was fascinating that Mr. Wilder pointed to the phrase competitively priced electricity. If we read that provision, our intent there in this initiative is that the pricing for that commodity should be set competitively. When I look back and read it, when I listened to Mr. Wilder read it, I realized, oh, wait a minute, I think I see what, what the issue is. Sometimes we say that and we say it's competitively priced, and that means it's cheap. But competitively priced actually means it's priced by competitive forces. So certainly we think it is easy for the legislature to, well, not easy, nothing's easy, right? But it is well within the possibility of the legislature's skill set to set up laws that permit competitive pricing of the electric commodity, and certainly not to run afoul here. And we also can set laws that are intended to reduce costs. That doesn't prejudge from what level they will be reduced, but the law should be bent on protecting customers, reducing costs, and allowing competitive market forces to work. So I hope that clarifies some of the questions, because I certainly could understand it as I was listening to the comment that those issues could be unclear here. And as you say, really it's just the 7 who make the decision, but that's the intent, as we were working on this.
No, thank you for that. And sometimes when we have some of these discussions, in my mind, I think of gasoline prices, in the sense of here at the commission and in some of the electricity conversations, we tend to break down myopically sometimes the different components of what go into rates. But in my mind, when I go buy gas for my car, I look at the service station and it has a price per gallon and then you have different grades of the gasoline, and different service stations have different prices. And but within those prices are also already incorporating certain federal, state, county taxes, raw costs of the fuel, and transportation costs, refinery costs, and that there's a lot that go into an overall gasoline per gallon rate. But when we talk about it, we just talk about the overall general rate, and different gas companies are able to do different rates for all kinds of different reasons. I can buy cheaper gasoline sometimes in Carson City than I can in Reno, and you can buy it sometimes cheaper at Costco than other places, and sometimes in my mind that's what I think we're looking at and trying to create on a certain level with this. Maybe that's an inaccurate analogy, but
Josh Weber, for the record, I think that's fair. Certainly, there are a lot of folks get electric bills. They see a number, but there's a lot of components in there, and certainly it's not the intent of this constitutional amendment to change all of those, but rather to look specifically at that one component, as with the gasoline analogy.
Thank you for that response. And one other overall question that came up last week that I still have in my mind is the impact of this constitutional amendment on existing contracts, purchase power agreements, PPAs, whether it's contracts entered into by co-ops or Hoover Dam contracts. Do you envision this constitutional amendment impacting those PPAs, for example, with, again, Hoover Dam or some of the co-ops?
Josh Weber, for the record. We believe that those contracts, particularly those you mentioned, CRC, Bonneville Power Administration, those contracts for federal power are vital and are a key component of that are supporting rural communities in particular. If we're talking, there of course is a section of federal power that goes to NV that's distributed, to folks in NV service territory as well. But I think federal law is very clear that those, as BPA calls them, preference power customers, are entitled to receive that commodity. Certainly, we would, I can't opine today whether or not, if we said BPA, no more, we're getting rid of these contracts. First off, it would be a terrible choice to make and a terrible policy statement. But were we to try and do that, I think there is every possibility it would be utterly preempted by federal law, and it certainly just simply couldn't happen. That said, I have seen people writing on this specific question and the Federal Power Act. I mean, there are a lot of laws that govern BPA's provision of power, which those northern co-ops enjoy, and there are a lot of analyses about preemption that have happened in other circumstances, and I can say that it's a mess, but ultimately, you don't likely go try and challenge federal contracts. Now, that's if you wanted to. Our position is you don't want to do that. You want to find a way to make sure those contracts work well within the construct of a re-regulated market. A bit tricky sometimes, but certainly possible, and we, again, believe both for BPA and for CRC, there are plenty of ways to make that happen.
Thank you. we're going to take a 15-minute break at this time. We've been going for about an hour and 15 minutes for our court reporter to have a little rest. And then we'll come back and I'll open up the mics to any generalized comments. I think our workshops will end by lunchtime today. I don't imagine them going longer than that unless other issues come up that warrant more discussion. But with that, we'll take about a 15-minute break or so and come back at 11:35. Thank you.
other one is SPP, which is out here.
Eastern Interconnection, yeah.
Okay.
And they would connect into some, take a overlay transmitted power between all the pressure. Eastern Interconnection is what they're right now. Because this is all synchronized base access. Yeah, so you have some DC connectivity. There's some that don't have. But yeah, it is the solder.
Easier to connect.
Yeah.
Okay.
Yeah, and the energy balance, and you know what's fun is you can just still have Pacific groups, and she's in pieces of items you want. But they're big loads on that. And they're in the turnover. And pieces of that, yes, special stuff. And then I joined the research freshman in line to join my people said, so yeah, you know. Not university. You know, the first thing you can know, down the years of time, Christmas came on day. But I just can't.
Colorado's trying to join SPP.
She's got all kinds of skills.
Excellent call on that. She got all the she had her advantages about how they. But initially doing things like creating a common FERC path. Because every utility had first preferred government center. She sales to be sales to
Okay.
and also what they charge for transmission, greater than the prosecutors.
Okay.
The whole thing, like in every sense, is like when you come to sell power from here to there or vice versa, you have to pay for all that.
Towards each.
They get you to change the system.
That's right.
All percentage for.
And each piece done, so.
Whereas if you have a regional market, it's all.
You can flow.
If you
We are back on the record in docket 17-1001, 01, excuse me. My name is Joe Reynolds, and this is day 5 of the investigatory workshop into the Energy Choice Initiative. A few final questions I wanted to pose out there before I open this up to comments. And one of these is a technical question to see if I could get any thoughts or possible answers, is that the cooperatives currently operate in territories that are specifically defined by our certificates of public convenience and necessity. Is there any thought of whether opening up a competitive market will require the Public Utilities Commission to cancel or amend or have to reissue some of the certificates of public convenience and necessity? Mr. Weber, want to take some thoughts on that? Thank you.
Sure. Josh Weber for the record. I do believe that the certificates of public necessity would need to be amended, because as they currently, and of course each one is somewhat different, but they currently allow only the holder of that certificate to sell electric power in the service territory. And of course, there's some interplay between the statute and the language on the face of the CPCN. So we'd have to look at each CPCN to be sure, because sometimes it's the statutory language, and some of them are kind of old documents. So I think that those are still appropriate to define distribution service territories and areas where not just the co-ops, but where NV has the right to build and operate the distribution systems. They, in the old days, nobody's imagining, we go back to the old days of running, an electric line down either side of the street, and the wires crossing, and the fires, and the safety hazards, and so on. So there is no intent to suddenly put distribution service territories into play as a competitive, house over house battle. There are states that still do that, and it's ugly, and that certainly is not the intent in this initiative. So to the extent, again, we have to look at the interplay between the law that authorizes CPCNs and that controls what a public utility may or may not do in and outside of its CPCN. So they may need to be amended.
Well, thank you for that. Another question I have is with respect to some of the PPAs, the purchase power agreements that have already been entered into by Nevada Energy. And we discussed some last week, and I know the Governor's Committee on Energy Choice has also had some discussions regarding those, and that we're potentially looking at quite a few contracts with different language assignment provisions or non-assignment provisions in them. Has any more analysis, I guess, by anyone openly in the room, or closer look been given to some of those contracts? Any more light to shed on that? I know some of my team has taken just a preliminary look, at least on a couple of those, but not, I don't think comprehensively on all of them yet. Is there any more thoughts on that, and what we may be looking at with respect to the legal effort that may be necessary in order to deal with those appropriately? Hello, Ms. Barbash. Thank you for coming up.
Thank you, Chairman Reynolds. I'll take a shot at that. We have a list, as you know, and we've provided that to the Governor's Committee on Energy Choice. And we're in the process right now of reviewing all those and the various provisions around assignability. And, we could probably address that better Friday, or if we're complete, if not by then, at least in our written comments.
No, thank you.
And we are assuming that those contracts will need to be abrogated or assigned if NV Energy is out of the electric provider business, obviously.
No, thank you for that. And we can take that up on Friday. Just because it's a legal issue, that was one that came up to mind on the break. So thank you. Mr. Weber, go ahead.
Josh Weber for the record. Just to follow up from the legal perspective, I did want to be clear since we're talking about the language of the initiative. The initiative doesn't say whether or not NV Energy or any other entity has to get rid of their wholesale power contracts. Recognize that's a business decision, and you know, NV, it's their company. The other folks who have contracts, those are their contracts. But there's has been kind of this language assuming that there has to be complete divestiture of all generation, and I do want to be clear that while that may be the decision, I totally respect, you know, each company has the right to do that. That isn't required under the initiative. Some folks in deregulated markets have held onto those contracts and continued to make wholesale sales. Obviously, I don't know other folks' contracts and whether or not that business is interesting to them. NV Energy, of course, has made some statements about what it wants and doesn't want to do, and that's fine. But from the legal point of view, I wanted to be clear that the question of divestiture is not decided by the initiative, but would need to be decided later on.
By the Nevada Supreme Court.
Or by the companies holding contracts.
No, thank you, Mr. Weber. I see Mr. Norris here on behalf of the Bureau of Consumer Protection from the Office of the Attorney General while we're talking about legal interpretations and the implication of Nevada law. Mr. Norris, do you have any, I know you spoke briefly last week during the initial workshop on this issue and mentioned that the office was monitoring this. Anything further you'd like to provide?
Sorry, Mr. Chairman, I didn't understand the question. I was too far in the back there.
More of it was just make sure that inviting an opportunity to comment. We're having conversations about a potential amendment to our state constitution and the impacts to Nevada law and Attorney General's Office, Bureau of Consumer Protection, our state lawyers. And so are there any thoughts or insights to any of these issues that you could provide?
Well, I think there is a substantial possibility that BCP, the agency I work with, will at least have to be recognized as having new duties under the law as it comes out for BC or ECI. There is likely to have to be some kind of staffing increase because of the role that our agency will play in trying to guarantee customer safety for the residential customers, to help them pick providers of energy and that sort of thing. Also, you know, there'll have to be a serious education process to indicate to those customers how they can help themselves under the ECI, and that would be the main thrust of what our duties become under that initiative.
Thank you. Is there been any thought, or is there any position on some of the interpretations of the constitutional amendments by the Bureau of Consumer Protection and what those may mean?
No, it hasn't been discussed internally at this point. I've pretty much been working alone for about the last 10 days on this. It took me that long just to read all the comments. But I'm sure as soon as things settle down a little bit, we'll be actively involved to a much greater extent than we have been so far.
Okay. Well, thank you. Thank you for being here today. With that, I'd like to just turn open first the microphones in Carson City. Is there any general comments on the issue of what laws may need to be amended, repealed, or added to the NRS or the NAC pursuant to this initiative petition? Morning, Mr. Van Cleve.
Thank you, Mr. Chairman. Brad Van Cleef for Valley Electric Association. I just wanted to address the question you posed earlier about the federal contracts that the co-ops are parties to. I think that in dealing with these contracts that we need to look at the specific language of each contract, because there's different language applicable to Bonneville compared to Hoover, compared to some of the other contracts that WAPA administers. And sort of the old paradigm with these contracts was that the buyer of the federal power had to resell that power and had to be used by the customers of that utility, so that the benefit had to flow to the customers of the utility. In October, new contracts took effect with respect to Hoover, new 50-year contracts. And in those contracts, it was recognized that the actual physical use of the power might not be possible. So I believe that most of those contracts allow the benefit of the Hoover power to be passed on to the customers of the utility. So the power could be sold in the market, and whatever profit was made could be distributed to those members. And with respect to Valley Electric, that particular way of doing it doesn't really work because it's in the CAISO. And the way the CAISO market works is that power is sold in to the CAISO grid at the marginal price at the location where it's delivered to the grid, and it's purchased at the location where the load is. And the difference between those marginal prices is referred to as congestion. So for Valley's contract, we negotiated a provision that said that any power that was purchased from Hoover could be sold at the marginal price at Meade, where it's delivered to the CAISO grid. So I think, at least in Valley's case, because it's in the CAISO, it's not going to present a problem with the federal contracts. I think with the other Hoover buyers, if there's an ability to pass on the benefit, I don't think that will pose a problem either. It could just be a credit on everyone's bill, whether they exercise choice or not. And with respect to the old contracts, I think there's two ways to address that. One, it may be possible to renegotiate those contracts. I think that, for instance, the Parker-Davis contracts come up for renegotiation in a few years. So it's possible that WAPA or CRC could put provisions in those contracts that would be similar to Hoover. And I guess if that didn't work, you might be able to basically sell the power to the customers of that utility and then allow choice for any purchase of their load above that.
Okay, thank you for that perspective. Are there any other commenters in Carson City? Seeing none, I'll go down to Vegas. Are there any commenters in Las Vegas on the issues of what laws need to be amended or repealed or added? Seeing and hearing none in Las Vegas, I'm going to wrap up today's session on the workshop. Tomorrow we will be going into the retail market and revisiting some issues that we touched on last week, which are options reasonably available to Nevada in designing and establishing a competitive retail electric service market, including but not limited to pros and cons, best practices, and structure for Nevada, and options for a provider of last resort. And as I, at least in my mind, focused a lot on the provider of last resort issue, we'll try to clarify a little bit more what that might look like tomorrow, as well as what options are available to the legislature in terms of requirements to enter into a retail market here in Nevada that we may want to start honing in on. In my mind, it's important not to be too restrictive in the sense that we don't want to inhibit market participation, but at the same time, we want good good businesses that are financially solid can do what they say they intend to do, and some vetting processes as well as any requirements that the legislature wants regarding what type of energy resources they'll be able to bring into the state. And so I want to have some of those conversations tomorrow. And with that, we'll adjourn today's meeting unless there's anything further. I'd like to thank everyone's participation and for being here today. And we will